So you have an agreement in place, you've already been to court, you have a child custody agreement, or what we call a parenting plan, and that parenting plan spells out the rights and responsibilities of both parties and the time-sharing arrangement that both parties have with the child. But unfortunately, things are not going very well, and things are to the point where you need to modify. Perhaps your ex-spouse has taken a job out of state, or moved somewhere else such that it's making it impossible or impractical to execute the time-sharing plan that you have right now. In these cases, you may want to modify the agreement that you have. Now, basic Florida law says yes, you can modify a time-sharing plan that you have. However, the courts don't want people coming willy-nilly coming back to court to try to modify things, so they make it a little bit difficult to come back to court. You need to talk to a lawyer and present the specific facts that you have about your particular case to make sure it makes sense for you to reopen your case and try to change the custody arrangement. Now, with that said, a lot of times in the original agreement, we'll put, if appropriate, language in the original agreement that says there's going to be a waiver by the parties of this substantial, material, and unanticipated change in circumstances. In other words, we'll put language in the agreement because we think there might be a problem in the future that will allow the parties to come back to court without having to meet this high burden. So you want to check your agreement to see if you have language that allows you to come back to court easily. Another place to look is if you have language in your agreement, your original agreement, that requires the parties to go back into mediation or arbitration before they come back to court. Because if you have that language, even if you talk to a lawyer and the lawyer says, listen, I understand that it's not really working great right now, but it's not really enough for us to open up a full-blown case. I don't think it's a good idea to do that. You can still force the other party to opt into mediation. And in mediation, it's an opportunity for both parties to change the agreement to try to work out a win-win to get something better than what they've had before. Now, you can always change your agreement at any time if the other party agrees. It doesn't matter what you've written. The Florida courts defer to the parents. So if you both agree that you want to rip up your time-sharing plan and do something completely different, you'll have no problem doing that. It's simply a matter of contacting an attorney to execute the right documents and get it filed with a court.